In today's what the hell? Oh, episode. This is an episode. Damn it! I have to remember what it is we do here. In today's episode of AutoInsiders with Ray Shefska, well, I'm going to be chatting with one of our favorite people and my favorite attorney, Joshua Feygin of Sue Your Dealer. Joshua, how are you today?
I'm doing great. Ray. Thanks for having me. How are you doing, my friend?
I am well, and I must say before we get into any meat and potatoes of anything today, for whatever reason, when I was thinking about your website, Sue Your Dealer, sueyourdealer.com, and I thought to myself, do you ever get phone calls from like some druggie that says, I need to sue my dealer?
Fortunately, no, at least not yet. But given the fact that I am in South Florida, I would imagine that it's going to happen sooner or later.
I would think it would have to, especially there. I mean, there's got to be some people that get confused. They don't realize that sue your dealer is sue your car dealer, not your drug dealer.
Yeah, it'd be pretty funny though.
Yeah. How would you handle that?
You got the wrong guy.
Joshua, let me ask you a silly question, or let me at least level set for the folks out there listening. You are a consumer protection attorney.
Sure.
Would that be the right phrase?
Yes,
and you practice in the wonderful state of Florida,
sure,
and Vermont, and Washington D.C. Simply because, well, you can, and between those three states, I'm guessing Florida keeps you the busiest.
Without a doubt. Without a doubt. Funny you should say that. Without a doubt.
Okay, and so you do your best to try and help people who have been, how should I put this,
taken for a ride,
screwed by a car dealer somewhere, taken advantage of, misinformed by whatever. Yeah,
taken for a ride.
Okay, that's good. Yes, and yeah, and so we know that because of car dealers, there's enough. You're a young man. There's enough work to keep you busy until you're a very, very old man.
Unfortunately,
it is unfortunate. But before we get into Joshua Feygin, lawyer, when you were a young kid, did you think to yourself, I want to right the injustices in the world. I want to help protect people. Did you like wake up one day as like an 8 or a 9-year-old and go, damn it, I want to be a lawyer?
No, not at all. I actually wanted to be a veterinarian, and frankly, I think I should have became a veterinarian now that I am an attorney. But everybody in my family did pretty much call it from the get-go that I would be an attorney, just simply because of my personality and the way I kind of went about my life. But yeah, no, I definitely didn't wake up at age 8 or 9 and say, hey, yeah, I'm going to go sue car dealers for a living. That's honestly, I didn't even realize that until I actually began practicing. I didn't even think of it until I finally got my license and actually hung up my shingle.
Wow. At what point in your life did you say to yourself, I think I'd like to be a lawyer?
When I realized I can't count.
Okay. So that ruled out being a CPA?
Indeed.
Okay.
I'll leave that to my mother.
Okay. Where did you go to law school? Just out of curiosity.
Florida International University, home of the Panthers in sunny South Florida.
Okay. So are you from Florida your entire life?
Actually, no. I was born in Brooklyn, lived in New Jersey for a while, lived in Pennsylvania for a while, and then I made my way down here, finished up high school, did undergrad at Florida International University, and then kind of matriculated into the law school there, went through law school, and kind of just stayed down here ever since.
Okay, and when you originally graduated, what area of law were you thinking of working in? Were you thinking, hey, I'll put out an ad and I'll write wills and things, things like that?
Actually, funny you should mention it. I started off with the aim of doing transactional law, particularly real estate.
Okay.
Prior to becoming an attorney, I had a real estate license, meaning I was a sales associate and a realtor. Up until about a year or two ago, I maintained that as well, and it kind of, I don't want to say put me through law school, but it definitely helped.
Mm-hmm.
It was something that I was familiar with. It was something that came naturally, so to say. Uh, After a while, I got really disenchanted with real estate uh, for a number of reasons. And at the same time, though, I was practicing door law. And for those that aren't familiar with the term door law, effectively, it's whatever that walks in the door and can actually pay your bills.
Okay.
So one day, somebody picked up the phone, called me, Josh. I know you're trying to get started. I have a client that I can refer to you. They own a dealership, and they just received a letter in the mail saying they're going to be sued. And can you do anything to help them? Me being who I am, I go, listen, why not? Let's take a look. Let's see what I can do here. Having absolutely, I don't want to say no experience, but very limited experience in the area.
Mm-hmm.
Took a look at the facts, took a look at the circumstances, quickly realized my client was SOL, and I did my best to resolve it for them. They were happy with the ultimate resolution, and then I kind of opened my eyes to this area of law. And that was pretty much where I started, and it pretty much snowballed from there.
And how long ago was that?
It's 2016.
2016.
Yes,
So
sir.
going on 8 years.
About.
Wow. Um, are you sorry you did it?
Looking back, can't cry over spilled milk, hindsight's 2020, and all those cute sayings. I don't want to say I'm sorry that I did it. It's definitely been an interesting journey. But looking back at it, there are certainly more lucrative areas of law. If I, really wanted to take advantage of all that the law has to offer, there are more lucrative areas of law. But I do get a sense of moral fulfillment by being able to help consumers. So it kind of levels out there in that sense.
So if I heard you correctly,
Mm-hmm.
part of your compensation is feeling good because you've helped somebody prevail in their case, and even though the financial rewards of the type of law that you practice might not be as great as some other areas of the law, the
Man, you
sense
missed the opportunity to be an attorney. What a wordsmith you are.
well, I'm working on it. But there's I don't know, this untold remuneration just in personal satisfaction of having accomplished something good.
Yeah, without a doubt. Without a doubt. It definitely helps me sleep at night, knowing that others aren't able to sleep at night because they're worried about the sort of, consequences for their harm for, taking advantage of an older lady, a foreigner, so on and so forth. So there certainly is a sense of moral fulfillment that fills that gap, so to say.
Uh-huh.
But yeah, listen, I looking at it, some of my friends are in the insurance defense field or in the insurance field, and they're doing very, very well for themselves. It's not to
Yeah.
say that I'm doing bad, but yeah,
Are
maybe. Who knows?
are you married?
I am. I am happily married.
Any children?
I do. I do have a sweet little daughter. She's a little bit over a year and a half at this point.
Well, bless you.
Thank, thank you. I try.
So so if your wife were to say to you, we need to take, what's your daughter's name?
Shia.
Shia. We need to take Shia on this really neat cruise. And you say, well, I don't know, honey. And she looks at you and she goes, what are you telling me the sense of satisfaction can't afford to pay for that?
Not quite. I don't think that we can have. We have to skip out on a cruise, but I'm definitely not moving into a mansion tomorrow.
Well, maybe not tomorrow, Josh, but I have a feeling that because of the way car dealerships operate, there will be a time when you're going to hit one of those generational cases that well, I don't know. You could be the Aaron Brockovich of automotive. Um, you
Let's
know,
hope. Let's hope. Unfortunately, though, even in my limited experience in the consumer protection field, I've noticed a general shift in the judiciary, and it's not a good shift. There's been a lot of recent Supreme Court cases and judicial decisions out of the appellate courts that are really chipping away at the rights of consumers. And this is something that's often, discussed, but realistically, when you're actually in the weeds, you notice
mm-hmm.
it a lot more. And it's almost as if every single decision out of the Supreme Court or the appellate courts lately is a negative one for the consumer. And hearing some of the cases that my mentors brought, years before, I wouldn't even touch those cases these days. And hearing that there were multiple figure cases which they prevailed on and made substantial money for both themselves and their clients, it just goes to show you how far we've come. And it's not a good shift, in my opinion.
I need you to help me with something.
Hopefully I can.
I think you might be able to.
I'm not a psychologist.
I've got faith in you. I've always thought, and I have a feeling you're going to correct me, and that my thought was wrong. But I always thought that somewhere along the line, law is based on some form of common sense logic. And I have a sneaky suspicion that I am like 180 degrees from reality. Am I?
What is that saying? The path to good intention, or something like that. What was the saying?
The road to hell was
the road to hell is paved with good intentions.
Good intentions, yes.
Yeah, that's kind of where I'm at with that. Yes, the law is rooted in senses of justice and fair play and so on and so forth, but that's all up to interpretation. And the interpretations that I've seen from late are very far from common sense. It's just unfortunate for consumers as a whole. That's the way that we're going. There has been a categorical shift in favor of the industry over the consumer. It's been slow and steady, but realistically, even the short amount of time that I've been practicing, I've seen it increase tenfold. But yeah, I mean, at the end of the day, there is common sense involved. But again, common sense isn't so common these days.
Well, that for me has always been the case. That the problem with common sense is it's just not all that common. But I always thought, and maybe because I'm a bit altruistic, I always thought that common sense and logic would prevail. That if you can make a logical argument as to why something is so, that should prevail. But yet, on a daily basis, I'm proven wrong.
Yes, here we are.
And I don't understand for the life of me how I could be that wrong about that all the time.
Yeah, I wish I had an answer. The unfortunate reality is that, looking at some of the arguments that have been made in the appellate of the Supreme Court and seeing the decisions that come out, I don't want to say that these are issues that have been predetermined by the justices or the judges that are reviewing these issues. But after seeing so many of the same sorts of opinions, it seems as if they're all on the same train, and it seems as if they're all in the same mindset. And, as much as I don't want to assume, it seems as if that almost categorically every federal judge in certain districts and certain locales is openly hostile to consumers in the way that they approach these cases. I might be cynical. I might just be in a position where I'm seeing it more and more because of what I'm doing, and I'm not really on the other side and seeing all the wins of the plaintiffs. Mm-hmm. But at the same time, I think I've seen enough to know where things are going.
So if we're headed down the path that it sounds like we're headed, based on what your experiences have been over the past 7 years or so, at what point will consumers have no rights?
It's hard to put an exact date on or a time frame, but a lot faster than I think we realize. There's a lot of pushes lately with the CFPB to enhance consumer rights. And I'm sure you guys have covered it plenty, and we've even discussed it in some fashion. But I don't really see that coming to a head. I don't really see that coming anywhere and doing much for consumers. I think it's just an opportunity for some lawmakers and some agency directors to show that they're putting in effort. But realistically speaking, not much comes of it. There have been some improvements, let's say with Zelle and peer-to-peer payment processing and whatnot. But other than that, I'm not seeing much change. And realistically speaking, it's happening a lot faster.
So as a consumer, and every last one of us is, even some of the federal judges are, But some of the things they might consume are different than some of the things you and I might consume. As a consumer, what could we do as a group, as a force to change that, so that somewhere along the line somebody says, yeah, they're entitled to some redress here.
Sure. So one of those, concepts, or one of those things that consumers can do as a whole, is to really spread awareness. And with that comes knowing what the issues are, and being educated in that sense. But one thing that I've noticed, at least in the state courts, there's a common theme that judges are not seeing a lot of consumer claims. Their day to day is usually contractual disputes, insurance disputes, so on and so forth.
Mm-hmm.
The consumer claims are very, very limited, at least with the way that I've been going through the courts and seeing other cases. And there's a disconnect there as well with the judges. They have never been, or most of them have not been, in the position of a consumer being taken advantage of, being put through the ringer, and they just don't have that connect with the consumer. So one, obviously, is to get the decision makers more educated.
Mm-hmm.
And the other is to put pressure on them. And lastly, vote. Obviously, the decision makers are only put in office by the voters. So another way to really improve this process is also to vote.
I agree with that, except
Can't trust a politician.
Well,
I already saw where you're going with that one.
All I was going to do was bring up one name, go George Santos, and
that's anomaly.
Well, is it? I mean, a politician can say whatever a politician needs to say in order to get elected. Doesn't mean that he or she meant what it was that they said in order to get elected. So I get what you're saying. Yes, there's value to voting and hopefully vetting the people that we vote for. But I don't feel real good about that. Do you think part of the issue, especially in the area of law that you practice, could part of that issue where the state judges just aren't all that familiar with consumer complaints is because, I don't know how many years ago it was, that the language changed on the back of a buyer's order to say that if there's a dispute, it has to be settled in arbitration?
Yeah, so forced arbitration has been the death knell to consumer claims being litigated. Forced arbitration, honestly, my colleagues and my mentors that have been practicing longer than I have, I've really talked about the good old days before forced arbitration became a thing, because it really allowed consumers the ability to seek redress in court, and not by a third party arbitration association that is being paid, and the proceedings in which are being paid for by 90 to 95% by the defendant or the industry member, whereas the consumer only pays a small fraction. So as much as I'd like to think that all arbitrators are perfect neutrals, obviously the term "don't bite the hand that feeds" really plays into that calculus. But yeah, forced arbitration has definitely limited the amount of exposure the county and circuit and state court judges for a whole are experiencing consumer claims. The other aspect of it is there's simply not enough consumer lawyers out there. Just look. I know of maybe 6 consumer protection attorneys in the state of Florida that practice auto fraud. I am one of maybe 3 that practices auto fraud almost exclusively.
Wow.
Everybody else has their hands in something else, like credit repair issues or credit reporting issues, for that matter, or debt collection activities, and so on and so forth. But there's just not enough of us, and I think that carries back to the discussion of, obviously, arbitration is not making it easy to advance these cases. And the other thing is, they're not. I don't want to say they're not all profitable cases, but you're kind of swimming upstream here with these cases. The dealerships will fight tooth and nail, even if I have them dead to rights. There are dealerships that I know for a fact, no matter what, I don't care how good my case is, I know for a fact We are taking this the mile. It's going to be a bloodbath. It's going to be a scorched earth approach. They're going to do everything possible to dissuade me and any other future consumer protection attorney that wants to sue them from suing them, just in order to chill that litigation aspect. So, again, I do think arbitration has had a huge impact, but as well as the fact that there's just not enough consumer protection attorneys in order to mitigate or counter all of the fraud that there is in this industry.
The industry seems to have no shortage of fraud. As far as you know, and I can tell you it's almost 100%, but as far as you know, any of your clients ever really read the buyer's order before they signed the damn thing? The front, the back with all the small words and small print with the big words and small print that you don't understand anyway.
So aside from the occasional professional, meaning, doctor, accountant, other attorneys, what have you, almost none. And more importantly, most of my cases involve a variation of hide the ball, is what I like to call it. And effectively, the dealership will have the consumer execute the contractual documents on a tablet screen that's about this big. Mm-hmm. And the actual document itself is on another screen that's facing the dealership or the dealership employee, or it's on the table and they're covering it, or they're covering the actual documents themselves. So not only, are they not reading the back, they're not even reading the front. They don't get the opportunity to actually see what is being signed. But honestly, even given the opportunity, chances are most consumers just don't simply have the ability to understand what it is they're reviewing. The terms are complex. They're in size 1 font, single spaced, all over the place on 50 different documents, with some terms that are even conflicting amongst the documents that they're signing. So you almost need a law degree just to be able to purchase a car these days.
Well, and those terms and conditions were written by your compatriots, I'm afraid. Yeah. And written in such a way to protect the dealership as much as possible. I mean, I know, like, for instance, at the dealerships I worked at, if there was a customer who actually read the buyer's order and saw the thing about forced arbitration and said, no, I don't agree to that, and they wanted to strike that, I said, well, I can't sell you the car.
Yeah, 100%. It's purely a contract of adhesion. It's a take or leave it, situation. Consumers have almost no rights in that regard.
No, and if they didn't buy it from me because they were upset about that clause was going to be on the buyer's order wherever they went to buy the car.
Exactly. They're not escaping it.
Yes, there's no way to get around it. Now, having mentioned arbitration, I believe you recently arbitrated a case that, worked out in your client's favor?
Indeed. So, as we've discussed on the podcasts with you guys, there has been a recent flurry of litigation in my office regarding end-of-lease buyout overcharges. Effectively, dealerships in the state of Florida and a few other states are seizing on the opportunity of individuals that decide to buy out their leased vehicles and tack on a whole plethora of charges that are simply not disclosed in the lease itself. Titling, well, not so much titling fee, but e-titling fees, registration fees, pre-delivery service charges, inspection fees, whatever that means, in order to make sure the vehicle is roadworthy, even though the vehicle is being sold as is 10 times over. CPO certification fees, so on and so forth. And the reason why they're doing this is because obviously, at least up until, I want to say, about a few months ago, there were severe in inventory shortages in the industry.
Mm-hmm.
Consumers were effectively purchasing the vehicles because they were upside for once, and at least as far as I can remember, that they were on the upside in their lease agreements, and there was actual equity in the vehicle that they were that they were leasing. So they would go ahead and buy out the vehicle, and the dealerships were hurting for money, obviously, because there's limited sales going on. There's not that much inventory, so they figured out a different ploy, and that ploy was to tack on these charges. I was interviewed by local news media. You guys interviewed me as well. We've had a number of discussions on the topic, and it just took off from there. Most dealerships come to their senses either at the start of the litigation or midway through, and realize what they did was wrong. And if they don't settle now, they're going to be settling or at least being exposed to a lot more at the long run. Unfortunately for Chrysler Capital, it was one of the few that decided to test their defenses, test their luck, and decided to take the case the entire mile. That did not work out for them at all. And they were the captive lease servicer in a lease buyout transaction with my client. My client was effectively overcharged by the dealership for certain services. And effectively, the arbitrator found that Chrysler Capital, although they weren't involved in the transaction specifically, they were still a lessor under the Consumer Leasing Act. And as a lessor under the Consumer Leasing Act, they have an affirmative obligation to disclose all of the fees that were going to be charged on the back end at the inception of the lease. And what really kind of sealed the deal for the arbitrator there, Chrysler Capital was saying, well, we didn't know what the dealership was going to charge on the back end. We had no idea. We had no control over that. Yeah, that's not how that works. And the reason for that is their lease agreement specifically has a line item that says, this is how much you're going to be charged to buy out the vehicle at the end of the lease. Well, there was a $350 surcharge there. My client was charged, I think, over $1,700, if I'm not mistaken. And that really sealed the deal for the arbitrator because they were claiming, we have no control, we have no control. Well, if you don't have any control, why is it that there is a disclosure there to begin with? And he didn't buy their excuses. He didn't buy, and rightfully so, didn't buy their claims. And it ended up very favorably for my client, and it ended up favorably for my office as well. And it's one of those instances where we did have a fair, impartial, neutral arbitrator. He understood the issues. We were able to explain it in a way that this arbitrator was able to digest. And effectively, he saw past all of the smoke and mirrors put up by Chrysler Capital. We have a few more moving forward to final arbitration hearing, final evidentiary hearing, that we have absolutely no doubt that we're going to be successful, and we have absolutely no doubt that there's going to be favorable awards. And we hope that this is going to set an example moving forward. One of the biggest problems that we have seen with these claims is that a lot of the dealerships are ponying, or let me rephrase that, a lot of the dealerships are effectively kicking over these cases to their insurance carriers. And the insurance carriers are picking up under an errors and omissions policy. They're saying, well, we charge these fees by accident, or we didn't disclose the fees by accident. And none of these dealerships really felt it in their own pocket, because the money that they were paying to defend the case and the money that was being ponied up to settle the case ended up coming from the insurance company's coffers. My hope is that more decisions we get and the more publicity we get is going to change the tide, and the dealerships are going to realize their premiums are either going to increase or they're just going to be dropped altogether because they're frequent flyers at this point. And my hope is, at least from that, there's going to be a change in the industry, and they're going to start realizing this isn't the way to make money.
What's interesting listening to you explain that is that we were talking about common sense a little while ago. And truth be told, Chrysler Capital had no control over what the dealer did. It was the dealership that committed the wrong. Chrysler Capital, because they were the leasing company, gets held accountable when it was the dealership that should be held accountable. I'm thankful that the arbitrator ruled in your favor and for your client, but common sense would say, well, no, it's the dealership that should have to pay. You just explained why dealerships don't care because, well, their insurance carriers are paying for it. That's where common sense seems to have fallen into a vacuum.
I would have to respectfully disagree, and the reason for that
You're allowed.
And the reason for that is, I believe that the lease servicers, the lender, effectively, is in the best position to police the dealerships. They know very well what is going on. They know very well, based upon the complaints that they're receiving from the consumers, that these dealerships are doing these things.
Okay.
I can't tell you how many countless times I've received calls from consumers saying, hey, I called XYZ lender, and I told them, hey, I want to buy out my vehicle. All of my friends are doing it in other states. I've heard that it's possible. And they say, well, no, we can't do that because we're not licensed as a car dealer in the state of Florida. Florida regulations require any entity or person that sells more than 3 vehicles a year to become licensed. They have to have a brick and mortar location. It exposes them to additional oversight and basically a bunch of bureaucratic red tape that they don't want to deal with.
Sure.
So effect, they're kind of going around and saying, well, we don't want to deal with all of this, so we're just going to throw you to the wolves. Go to these dealerships, and they'll do the buyout for you, and they'll do the paperwork for you, and that's it. Well, the consumer then goes to the dealership, gets saddled with $1,500, $1,700, in some cases up to $7,000
Okay.
in additional fees. And they go, we don't want this. We just want to buy out their car. We don't need certification. We don't need CPO. We don't need any of this junk. Why are you charging me fair market value for the vehicle when the lease discloses the purchase option? And they go back and they call the lease servicer, and the lease servicer says, well, try a different dealership. And they go to another dealership, same thing. Well, after so many of these complaints, they really need to put a crackdown. Ford, from what I understand, has. Infiniti and Nissan have. And there have been a few other, anecdotal reports that there have been crackdowns, so to say.
Okay.
But the practice is still prolific.
So, I think your respectful disagreement put me in place, and I get it, because basically what I heard is that they don't want to have to go through the process of becoming licensed and having a brick and mortar location somewhere so that they can facilitate these lease buyouts. So, yes, they've kind of shirked their responsibility. I get it. Why is it, with all of this that's going on, and it's been going on for a while in the state where you live, why isn't there a carve out to that by the state legislature, there it is, I knew I could say it correctly, to allow leasing companies to allow their clients to buy out their lease without having to become a dealer? Why can't the state just resolve the issue that way?
How should I put this? I think there's too much private influence coming out of the dealership lobby to allow that to occur. And I'm saying that as gently and as politically correct as I can.
Okay.
Effectively, if there was a push and that law or that carve out came to be, dealerships, in my opinion, would lose a huge profit center in a time where they can't afford to lose.
But it was never meant to be a profit center.
I don't disagree.
Okay, it was.
I don't know what to say to that. I definitely don't disagree.
Yeah. I mean, it was never part and parcel of the whole damn thing, because in 99% of the cases, the residual value is higher than the vehicle's value, so that the customer was always compelled to either turn it back in or just give it back and lease another vehicle. Sure. But suddenly we ran into this thing called a pandemic and a shortage of cars, and we were in that one time in history where consumers actually had an advantage and they could buy out their lease at the end for, I don't know, 25 to 35% below market value. And dealers didn't like that. And they wanted to figure,
the consumer gets a good deal.
Yeah, no, they hate that. But in the old days, they would have just gotten the car back. Now they weren't getting the car back, and they figure, okay, we're losing $2,000-$3,000 in potential profit. We got to figure out a way to make it up.
Sure.
And it's just maybe I'm asking for too much, but at some point, wouldn't it just be nice if, I don't know, your elected officials looked around and said,
it wouldn't be nice if the elected officials served the people?
Yeah, the people that voted for them. Yeah, let's reward our constituents with actually doing something for their benefit.
Yeah, if only.
Yeah.
In a perfect world, right?
Well, I know we don't live in a perfect world, and I say it probably. I'm 72 years old. I don't know why I keep thinking that we're going to change the world and we're going to change the way these people operate. But if there aren't enough of us out there who say, we can change the world, it will never change. So
That's a good way
you'd
to look
think
at it.
after banging my head against the wall for 72 years, I'd be smart enough to stop hitting my head, but apparently I'm not.
Yeah.
Uh,
Yeah.
yeah, no
Guess you
wonder
like
my
the
father.
feeling, right?
Yeah, no wonder my father called me a moron when I was younger. Yeah,
Oh,
I would do or say something, and my father would look at me and go, "What are you, a moron?" And I'd look at my father and I go, "I love you too, Dad." That was his way of saying I love you.
the northerly tough love.
Yeah. Uh, oh my goodness. Um, have there been any other big wins that you've seen recently in your practice?
Honestly, every win is a big win, in my opinion. Any time that a consumer is able to get redress from effectively a Goliath, it's a win. Really, a good portion of my practice these days is dedicated towards these lease buyout claims. They're slowly starting to dwindle down in the numbers.
Mm-hmm.
One thing that I'm starting to see more and more, and I think this is a sign of the times, in addition to repossessions, obviously, as we discussed last time we spoke, late payoffs for trade-ins. And recently I took on one of these cases. The consumer, they were fully in the right. They delivered a vehicle to a dealership with the intention of trading it in. There was negative equity, a very marginal amount of negative equity that rolled into the new deal. The dealership took on the vehicle, put it in their inventory, waited 3 months to sell it. Once they actually sold the vehicle, the consumer's credit report was absolutely destroyed with a charge off. And as a result, the consumer was unable to take advantage of relatively low interest rates. This was obviously during pandemic times,
Yes.
and they lost out on a mortgage. They effectively, their life was uprooted in that regard. And I don't want to jinx myself, but we're at a position right now in the litigation where we believe that it's going to be an absolute disaster for the dealership. And I think the dealership is also realizing that this is where it's going, and the numbers that are being thrown around are very, very, very reasonable for the consumer. Obviously, it could always be better, but seeing that the dealerships are starting to become a little bit more scared, particularly in this climate, I think that's
Mm-hmm.
a huge, huge plus. But other than that, I mean, listen, everything that I've been seeing, every settlement, like I said, is a big win in my opinion.
So what you were just saying was that the customer traded a car and the dealership, as part of its obligation, because it rolled the negative equity into the new loan, part of their obligation, and I'm sure they had the customer, your client, sign a payoff authorization stating that once the loan was paid off, the title was to go to the dealership that paid it off. Um,
Exactly.
so if I'm hearing correctly, the dealer never sent the payoff. And
Correct, and it's a common in occurrence in the industry as of late. It's really a sign of the times. Effectively, it's called floating inventory. There are a number of state regulations in other states that particularly prohibit this type of activity. But
Mhm.
effectively, what happens is when the dealership writes that loan for the next vehicle that the consumer is buying, a portion of the loan amount is to go towards the
The
payoff.
payoff.
Obviously, the money doesn't come out of thin air.
Yeah.
And effectively, what the dealership does, instead of making that payoff, they hope that somebody's going to come in and pick up that vehicle and purchase it before the next payment is due. So what they do is they will take the money and they'll use it to fund the overhead. Well, not always. It doesn't always occur that somebody comes in and right away they want to purchase the car. Even in today's market, in this particular instance, the consumer's credit, I'm sorry, the consumer's account became delinquent and the credit became affected because of, I believe it was 90 days, if I recall correctly, that they didn't sell the vehicle. And the payoff, interestingly enough, when I got the vehicle's title history, it showed that the payoff occurred 1 day after the title was transferred to the new buyer. So the timeline of events, it's very clear. And
Mhm.
because of all of this evidence, we were able to flesh out that this wasn't an issue internally. This wasn't an issue with the client's, credit reports. This wasn't an issue because my client didn't do something on their end. It was purely the dealership's greed and their refusal to live up to their obligations. And speaking of obligations, under Florida law, anytime a dealership takes in a vehicle on trade, they have an affirmative obligation to complete that payoff on a purchase money lien within 10 working days of taking possession or acquiring ownership, for that matter, of the vehicle. 90 days is obviously in excess of 10 days. So
Yes.
they're in a world of hurt, in my opinion.
Yeah, I mean, what you just said, I mean, that's why dealerships always call and get a 10-day payoff,
Indeed.
because, well, they know they have to pay it off within 10 days. And and if you're the dealership and you wait 90 days to pay it off, my God, the additional charges on that payoff, the payoff is much, much higher than what you had originally factored and figured in.
Yep. Without a doubt. And the interesting thing is, the flip side there is, I've had some dealerships effectively try to sweeten up the deal on their end by failing to make the payoff in excess of 30 days, 60 days, 45 days, or what have you. And the consumer keeps on calling them, hey, what's going on? What's going on? What's going on? I don't want my credit to take a hit. Don't worry, don't worry, don't worry. We'll pay you back. Just make the payment. There's issues with whatever's going on. And of course, you already know where this is going. The
Yeah.
consumer makes the payment, and they go, well, hey, I've made this payment. I've made 2 payments. You guys have still not made this payoff. I've made 3 payments. And the dealership goes, well, I don't know. We'll talk with our manager. We'll talk with the controller. We'll talk to whoever it is. And they hope that the consumer simply disappears and nothing comes of it. And effectively what they're doing is they're reducing, and it's just such a foolish approach, because they're opening themselves up to considerable liability in that regard, but they see it as an opportunity to sweeten the deal by
Sure.
$500,000, whatever it may be, given that the margins are already so small in the transaction. Whatever they can get out of it helps,
So,
apparently.
so what is it then? Because I was in retail automotive for 43 years. I mean, we never messed around at the dealerships I worked at. We never messed around with a customer's payoff. I mean, we made the damn payoff. Um, I mean, how does the consumer protect themselves from this type of stuff in the future?
Immediately, the second that there's an issue on the horizon, immediately get the local DMV involved. File a consumer complaint and get somebody to oversee it. I can't tell you how many times that I've gotten the runaround from dealerships, or at least consumers have gotten the runaround from
Sure.
dealerships, saying, the dealership saying, well, this person is out. We've had to downsize our workforce. We're training a new person. Title clerk is absent. Somebody had a meeting with God yesterday and they were unable to come in today. Whatever excuses they could possibly drum up, they're not making those excuses to the DMV examiner. I don't want to say that the Florida DMV is particularly effective in their enforcement capabilities and their abilities in general, but usually once an examiner gets assigned to the file, it's unbelievable how quickly the check gets overnighted to the finance company. And it goes from I don't know to I don't know what happened, and here's a canceled check that we allegedly sent yesterday, to here's the actual confirmation of the payoff and the lien satisfaction. So that is something that most consumers need to stay on top of. And the other thing is, don't take a dealership for their word. I call dealerships stealerships for a reason. If the
Sure.
dealership's telling you, if the dealership employees' lips are moving, it's almost guaranteed that they're lying to you. So do not take them for their word. In the event that they're, and it doesn't, I hate to use blanket statements like that, because there are
Sure.
good
No, I
dealerships out
understand.
there. But my experience, obviously, where I'm at, is that there is just so many bad apples that it's absurd. But don't take the dealership for its word. And if it's spoken, it's almost as if it's never happened. If the dealership promises something to you, make sure it's in writing. Make sure that you stay on top of the transaction. Don't take somebody's word. Always be on your own side, meaning make sure that you are watching out for yourself.
I mean, that is just,
That's common sense, but again, common sense ain't so common.
exactly. And the sad reality is that so many people have negative equity, um, that they need the dealership to make the payoff. And typically the dealership isn't going to make the payoff until they get funded on the loan, because it's the funding from the loan that allows them to have enough money to pay the vehicle off and all the negative equity on that vehicle. But if dealerships aren't doing what they're supposed to do, I would think the best way for a consumer to protect themselves when they have a vehicle that they're trading is, well, they can't trade it, unless they get a personal loan to cover part of the pay. I don't know.
Yeah, in this day and age, and this is going to be becoming more and more prevalent, that people are going to be so deep underwater in the vehicles that were sold for 10, 15, 20, 30% over MSRP because of
Hmm.
market adjustments.
Yes.
Um, it's going to be almost impossible for a consumer to trade in a vehicle without the assistance of a dealership.
Yes.
It's just absurd what I see the tidal wave coming, and the only thing I can do is hold on and get ready for the ride. But yeah, I mean, in this hypothetical scenario, even if the consumer does get a personal loan, it still doesn't make sense. I mean, it might not be financially worthwhile for them. One,
Yes.
two, it's still not going to prevent the dealership from dragging their feet unless they get a loan
Exactly.
for the entire balance. And even so, I mean, it's difficult.
I, I,
It's one of those situations that there isn't a perfect solution or perfect answer. But again,
I,
that's what
I
you need
guess
these for.
I guess what the consumer could do, is they could arrange for a personal loan and they could agree to sell the vehicle to some other party, some other entity, um, and but you're still not guaranteed that that entity is going to make the payoff, even if you give them the check, even if you give them a check for the negative amount that you still owe above and beyond the value that the entity placed on the vehicle. It is That's ugly. Um, are,
Indeed.
are these type of situations, are these more prevalent in used car only facilities, or are you seeing it in many of the new car franchise dealerships?
You know, oddly enough, and it's quite scary in my opinion, but this is more prevalent in the bigger franchise dealerships.
Oh my
I
goodness.
think the franchise dealerships are in a world of hurt right now. And just looking at the landscape and how much it's changed within the last 2 years, there are three particular out of state dealership groups that have come in and just swept the boards, and they have just taken over and purchased a lot of the smaller franchise dealerships that we have around here.
Mm-hmm.
Now they're under different management and so on and so forth, which is realistically a sign of the times. I mean, only the strong survive.
Certainly.
And but again, I really see these issues with mostly the franchise dealerships. The smaller mom and pop dealerships, they're scared. They are much more scared because they can't afford the lawsuit. They can't afford the regulatory issues that come with it. They can't afford to get their license suspended. The bigger dealerships, on the other hand, have a good chunk of change to spend in defense costs. They have insurance policies for these things. They have reserves put in place in order to mitigate against any potential loss that might come from a lawsuit in this type of instance, which kind of inhibits this reckless sort of mentality that let's take a chance here. Let's see what happens. And if nothing else, it's a short-term loan. We don't really care what happens to the consumer because they need our product, and there's not that many vehicles these days. So let's see what happens.
My God, you, my friend, are going to have a job forever.
Yep, unfortunately.
Oh, well, it's. Do you see similar things happening, say, on the real estate side of things?
I'm frankly, I'm not that in tune with real estate anymore. I like to call myself a recovering realtor. I escaped the industry, and I haven't really looked back since. So I would imagine, yeah. I mean, listen, I can't imagine that the auto industry is the only industry that is experiencing these issues, right? We just got to look at the news. Unfortunately, look at the day to day events. Things aren't that well in the economy, and things aren't going to be doing well anytime soon. So, I would be surprised if these issues aren't, or similar issues aren't popping up in other industries.
I guess anytime there's large sums of money involved, there can be issues.
Always, always,
Uh,
money is the root of all evil.
no, no. As somebody reminded me when I said that last week, it is the love of money that is the root of all evil. I
Okay,
stood
fair,
corrected. See,
fair, fair. I stand corrected.
See, you helped me earlier. I helped you now.
There you go.
uh, do you? I know you have a law license for DC and Vermont. Do you handle very many cases in either one of those jurisdictions?
Not as many as Florida. Not anywhere near as many as Florida. It just I'm not sure if it's a byproduct of the marketing or a byproduct of just different cultures, for lack of a better term. But Florida seems to breed fraud. It's like I've said before, a sunny place for shady people. Um, the regulations that are in place favor the industry. If you again, I hate using blanket terminology and blanket assessments here, but generally speaking, all of the consumer protection statutes that are out there in the state of Florida really are nothing but regulations in favor of the industry. And same thing goes for the DMV regulations. I think I wouldn't be surprised if you look into the DMV regulations, and what's required to get a license would be that the individual has a pulse and
Yeah,
nothing.
yeah. If you could fog a mirror, you can probably get a license.
Based upon some of the depositions that I've taken of dealership personnel on the higher levels of the dealership organization, I can confidently say that the regulations are, in my opinion, not strict enough as to who can get a license and what it takes to get a license, because almost anybody can. I'm not sure if that's the case for DC and Vermont. I'd be surprised if it was. I do believe both of those jurisdictions have much more arduous screening processes, but unfortunately, that's not the case in Florida. Florida definitely keeps me the busiest.
Do you, do you, do you think there will ever be a cap placed on the amount of how much a dealership can charge for dock fees in Florida?
Never,
Because never.
never, never,
Oh my,
never,
yeah,
never, never.
because they are categorically the highest dock fees we see when
Yeah,
we're working deals for customers. It's so much higher in Florida than it is anywhere else in the country.
yeah. I had a dealership representative, corporate representative, in deposition, and when I asked them why is that the case, why are your fees so high, I almost couldn't hold back my laugh. But he goes, "High cost of living down here." And I'm like, what does a cost of living have to anything to
Yeah,
do with how much it costs for you to recondition a vehicle,
yeah,
right? What are they doing? Maybe putting it out in the rain so it gets all the dust off of it, and that's it. Vacuuming it once, maybe, and that's it. But I hope within the next, I want to say 3 weeks or so, I should have another arbitration decision against a local dealership. It's a very well known, larger franchise dealership who was charging 30, I want to say either $3,000 or $3,500 in documentary fees for the buyout. And in order to circumvent the lease buyout
hmm
statute, Consumer Leasing Act, and in terms of the lease, they had consumers execute this cute little addendum that they prepared saying, I am voluntarily going through this transaction. I am voluntarily agreeing for you to charge me this amount for the benefit of you preparing the documents related to the purchase transaction of this vehicle. How that is any different than anything that they do on their day to day basis when they are actually preparing the lease from the inception or when they normally do this buyout, it's mind boggling. There's absolutely no difference. But obviously, there's a lack of choice. The consumer doesn't have the ability to go elsewhere because the next dealership is going to probably charge them the exact same thing. So I hope, I'd love to give it to you today, but I want this arbitration for
No,
obvious reasons. I want
absolutely.
the arbitration proceeding to terminate. And then once we get the award, I'm going to be sharing it far and wide. The interesting thing is this particular dealership, they thought it was wise to fight me from the get go,
Yeah.
dragged me into arbitration. And now that we're in arbitration, instead of filing any sort of answer or defenses, they have outright admitted liability. They don't want to fight me. They just wanted to drag me into arbitration, get
hmm
me in front of an arbitrator, admit to liability, and then have the arbitrator decide how much I'm entitled to attorney's fees, in the mistaken belief that the arbitrator is going to be in favor of the industry as opposed to the consumer. Um, I don't believe it's going to work out in their favor. And I don't believe that this was a smart decision on their part, because now I'm going to have an arbitration award that very clearly states they admitted to liability, and that's going to set the groundwork for future litigation in this regard. But that was their decision to make. I look forward to seeing how it ends up for them, and I look forward to sharing both the arbitration award and the addendum with you guys, so you can spread it with your viewership.
Well, and we will. I can promise you. One final question.
Sure.
What can I do and Car Edge do to help further educate consumers so that maybe, I don't know, you won't have quite as many clients? I'm sure you'll always have more than enough, but so that we can try and level the playing field a little bit, so that these situations don't arise. Is there anything that we can do that would help?
Above and beyond what you're already doing, I can't imagine that there's anything else left at this point. You guys do an absolutely phenomenal job of educating consumers, bringing these issues to the viewers. There's simply not enough being done in that regard. And the fact that there is a easily digestible podcast that allows consumers to understand what it is that's going on, how to look out for these things, I think that's a huge plus. Aside from that, don't know. I wish I had that answer for you. I think you guys are doing a wonderful job. I think the focus needs to be more so on the actual consumers' rights, and the fact that there are attorneys that can counter these issues for them. One of the common themes that I get from people that contact me is that we didn't know that there were attorneys that practice in this area. We didn't know that this was an actual area of law. We were talking to business litigation attorneys. We were talking to contractual attorneys before we stumbled across you. And, that has a lot to do with the fact that there's just simply not enough of us out there. But at the same time, consumers don't realize that consumer protection is an area of law, and that there are attorneys that specialize and focus specifically in representing consumers against the industry.
Wow. Well, I guess we need to spread that word more than we have been. And if I heard you correctly, we need to grow our damn audience so we can be reaching even more people and hopefully helping.
Indeed.
Josh, I cannot thank you enough for spending, just about an hour with me today. You are always a breath of fresh air and a wealth of information, and somebody who's got his fingers on the pulse of what's going on and fighting that good fight in that uphill battle apparently every day. You're welcome back anytime. When you get that arbitration notice, let us know, and we will blast it all over our airways for you as well.
It's fantastic, Ray. I really appreciate everything you guys are doing. I appreciate you inviting me on. Look forward to future podcasts and interviews.
Absolutely. We'll have you back, I promise. If you'll do it.
I'll hold you to it.
Okay. Thanks again, Josh.
Always a pleasure, Ray.